Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of Samfiru Tumarkin, LLP, and the Western Canada practice leader on all things disability, critical illness, and life insurance claims. Please send your messages through the social media platforms, or your questions rather, and I'll get back. I'll review them as they come through. We've got about 30 minutes, and I look forward to your questions. So, first thing that has come up, I'll read this, is do chronic pain conditions qualify for LTD? This is often a thing that I think people get confused by is, if I have this type of condition, will I qualify for LTD? In other words, will the insurance company approve my claim to have long-term disability benefits paid? The most important thing in any disability claim is functional impairment. Yes, a diagnosis is important. So if you have depression, anxiety, chronic pain, chronic fatigue, multiple sclerosis, whatever it may be, those are important facts. But the most important thing is functional impairment. Does my condition impair me on a functional level to the extent that I cannot perform the essential duties of my occupation? In other words, what they're looking at is restrictions and limitations. Now, the problem with chronic pain, because sometimes these cases do get approved, but often they get denied, or the insurance company may have paid it for a period and then decide to deny the claim. Chronic pain is often very subjective. In other words, I'll use an example. Somebody may have had a car accident 10 years ago. They may have recovered from the car accident, but they continue to struggle with pain. Imaging shows no impairment. In other words, the findings are normal. There's no fracture, there's no impingement, there's no disc herniation, there's no bulging disc, yet the person suffers from chronic pain. And that may be due to many reasons. In cases like that, it is often referred to as a subjective condition. And there's case law on this, where there's an expectation for someone to work through pain in order to remain at work, which insurance companies often rely on. But what has to be considered is a person has to exert reasonable efforts to work through pain, not incredibly beyond human strength, or have pain levels or pain resistance to the extent that they're in so much pain, but they have to carry on working. If you and your doctor have a discussion and the doctor agrees with you that due to chronic pain, you cannot work, then you can apply for long-term disability. The question often arises, what evidence should you submit if you have a claim for chronic pain or any other claim? Let's focus on chronic pain for a moment. If you have such a claim, you first have to have your doctor complete a document called an attending physician statement. The attending physician statement is the document that is part of the initial application. There are three documents. The one is the employee statement, something that you complete. The second is the attending physician statement, a document that your doctor completes. And the third is the employer statement, or the plan sponsor statement, which is a document completed by the employer. The doctor's one is crucial. If the doctor is simply going to say, my patient has chronic pain and cannot work, your claim is going to be denied. There has to be an indication of what investigations have been done. Why does the doctor say that you cannot work due to chronic pain? In other words, and I've used this example before with depression and anxiety. If your doctor says you have depression, you cannot work, the insurance company likely was going to deny that claim. You have to delineate and explain, give further evidence. Why can you not work with this condition? Because many people work with depression, many people work with chronic pain. How does that condition impact your ability to perform the duties of your occupation? In other words, what are the restrictions and limitations? And it's, of course, crucial to understand what the person's occupation is. If it is a heavy labor-intensive job, for example, you work as a laborer, you work as a gardener, and you have a bad back, you cannot bend, you cannot lift, you cannot stand for extended periods of time, you cannot do physical labor, then that claim should be approved. I often see cases where chronic pain is approved, but when it gets to the change of definition, the insurance company then denies it. And what that means is the insurance company, after having paid a claim for a period of time during the own occupation period, then assesses whether you're able to work in any other occupation for which you have the transferable skills, and that would pay to you a certain percentage of your pre-disability income. What often happens is when somebody has I'll use this as an example because I've seen so many of them, somebody who works as a truck driver. It's not simply the extent of driving, they also have to do physical labor, offloading and loading the truck. Those cases may be approved during the own occupation period. Then the insurance company comes around and says, okay, well, we've looked at your transferable skills. We believe you can work in another occupation based on your transferable skill sets, which for truckers almost always seems to be that the insurance company believes that they can work as a dispatcher or in some other truck-related sedentary occupation, which means, though, that the person should sit for an extended period of time. And when we get involved in these cases, we usually have people who have had such a bad back doing truck driving for a long period of time that they cannot sit for extended periods of time. They cannot work in a sedentary occupation. And the insurance company may say, well, we think you can, and deny the claim, and denies the claim. If that is a situation that you are facing, please contact us so we can review with you your personal circumstances. We can review the denial letter and the medical evidence that you may have available, as well as the policy. Then we can discuss with you what your options are in order for you to make an informed decision. The insurance company may offer to you an appeal, which is a process where the insurance company is assessing its own denial. It's not a third party, it's the same entity that denied your claim that is now deciding whether it should overturn its decision. That's one avenue. The other avenue is pursuing a legal claim, which for most people is an option. Some unionized employees cannot do that, but for the most part, people are able to choose between the two options. We pursue legal claims on behalf of clients, which allows the client to focus on their treatment. They don't need to speak to the insurance company any longer. All communications go through us, and you can focus on your treatment, and we focus to get the best settlement that we are able to obtain through the process of a legal claim. So if you have a denial and you want to have a discussion about it, know that we offer free consultations. In other words, you can contact us, we will review the documents with you and offer you a free consultation to allow you to make an informed decision. We work throughout Canada, other than in the territories of Quebec, with offices in BC, Alberta, and Ontario. I see the questions are coming in, so let's go to the first one. Robin Billinghurst asks, if my doctor says it is unlikely that I will ever be able to return to my job, what happens then? It's a good question. So first thing that I see is unable to return to my job. If you have a disability policy through your employer, in other words, coverage under a group policy, that policy likely will have two definitions. The first one, you have to prove that you cannot perform the duties of your own occupation. The second one, and for the most part, it's 2 years, the own occupation period. Some cases it's 1 year, others it's 3 years, but for the most part, it's 2 years. When that phase ends, then you have to prove that you cannot perform the duties of any other occupation for which you have the transferable skills, in other words, based on your education, your training, and your experience, that would pay to you a certain amount of income, in other words, a certain percentage of your pre-disability income, and that you are physically able to do within your restrictions and limitations. So if your doctor says it's unlikely that you will ever be able to return to your job, the insurance company may pay to you the own occupation period, but likely will do a reassessment when it gets to the any occupation phase of your policy. I get this question a lot where people say, my doctor says I'm never going to work again, or I'm never going to be able to do this again. The insurance company doesn't look at it that way. It depends, of course, on what your condition is. Your entitlement under a disability policy is a monthly benefit. In other words, it is incumbent on you to prove that you remain disabled within the meaning of the policy on an ongoing basis. So if your doctor says, my patient is not going to go back to work with this occupation, do not assume that the insurance company is going to accept that, not adjudicate the claim on an ongoing basis, and just continue to pay you benefits. You, at your end, have to do your part as well, which is required under the policy, in order to avoid a potential denial. So if you have a doctor advising that you cannot work in your own occupation or any occupation, your duty under the policy is to regularly see your doctor, your physician, which means you're remaining under the regular care of a physician, and you are following through with recommended treatment. Those are requirements under the policy, and if you don't do that, the insurance company may deny you based on that versus saying that you're not disabled. So at your end, do what is required. Make sure that you don't make it easier for the insurance company to deny your claim. I hope that answers your question, Robin. If you've got further questions, you can respond here or you can contact us as well. Then there's a question on YouTube from Connor. My insurance company is asking me to apply for the Canadian Disability Pension, which is CPP disability benefits. Why do they want this, and can they force me? It's remarkable how often this question comes up. So let's start with basics first. You're receiving benefits under the terms of a policy, which is a contract. The policy requires you to do certain things. Like I said, you need to remain under the regular care of a physician and follow through with appropriate treatment advice. The policy may also say that if you are eligible for other benefits, in other words, income from other sources, due to your disability, then you should apply to those. And if you don't, the insurance company may say that the policy allows them to estimate what those benefits would be and to deduct it if you refuse to do so. Not all policies say that, so it's very, very dependent on what your policy says. But it allows the insurance company to deduct the amount that those other sources would pay, which of course means that they're paying you less money. People often look at this as a downside, but look at the positives of applying for CPP disability. If you were to be approved, you're applying through the federal government, by the way, so that's with Service Canada. The test for CPP disability is you have to show that you have an illness that is, number one, severe, number two, prolonged, and number three, to the extent that it prevents you from engaging in any gainful occupation, which is similar to the any occupation phase definition in your policy. So you may argue or take the position with the insurance company that if you're approved for CPP disability benefits, even the government accepted that you cannot work in any other gainful occupation. Yes, the insurance company can deduct that amount, but many policies that you have through an insurance company will not have something called a cost of living allowance increase. In other words, every year the benefit increases. Many of them don't have that. Some do, but many don't. If you apply for CPP disability benefits, there is an annual increase. And that annual increase is often not an offset under the insurance company's policy. So whatever the increases that you receive every year, that probably should be yours and not be deducted by the insurance company. Another benefit may be that if the insurance company denies your claim, CPP disability benefits are not as vigorously and regularly assessed by Service Canada. Once you're approved, you should continue to receive those benefits unless Service Canada, for whatever reason, decides to reassess. So if your claim is denied with the insurer, if you're getting CPP disability, hopefully you will continue to receive those, which will provide you some form of financial cushion. There's one more point to be made. If you have children, it depends on what the ages are, of course, you may be qualified for CPP disability child benefits. So if you qualify for CPP disability benefits, you may also get a child benefit, which under most policies is not a direct offset, but it may become an indirect offset. The point being that if you do apply for CPP disability benefits and it's approved, there are various arguments that you can make with the insurance company as why they should continue to pay your claim. And the cost of living allowance increase generally is not deducted by the insurer, which means ultimately you're going to get more money. I hope that answers that question. I know it was a very long question, but it was an important thing to understand. Let's just go back to Robin for a moment before I move on to the next question. Robin says, if this changes my employment status, like my employer lets me go, does this impact my coverage? If you're receiving benefits from an insurance company, in other words, you applied through your employer's group insurer, and they are paying to you long-term disability benefits, and at some point after that claim was approved, the employers now they're going to terminate your employment. That should not impact your existing claim. Will it impact future coverage? Yes. If you were no longer to be disabled under the policy, you likely will not have coverage under the policy because you're no longer employed there. but it should not impact your existing claim. So you should continue to receive long-term disability benefits as long as the insurance company accepts that you are disabled. Okay, question on YouTube from Jason J. What is the difference between PWD and LTD? Okay, so PWD, this is a question relating to British Columbia. PWD is a designation, persons with disabilities, that is made by the provincial government. The difference is long-term disability is paid by an insurance company. It is based on you having paid premiums, so it's a private benefit that you're getting. PWD is a benefit that you're getting from the provincial government. My understanding is that if you're getting long-term disability, the chances of you receiving PWD are not high because they do look at income that you're receiving from other sources to see whether you qualify. I've seen many cases where people were denied long-term disability or were being paid LTD and then their claim was closed or terminated. Then they applied for PWD. Then the insurance companies often take the position that that should be an offset, which I disagree with, because my position is if long-term disability had been paid, as was the duty of the insurance company, PWD would never have been approved. So if you have a situation where you are not receiving LTD or where you are receiving LTD, you can still contact the provincial government to see whether you would qualify for PWD, because it is not simply an assessment of benefits. I think you may get other benefits as well, which may not be an employment subsidy, but it may be in relation to medications or dentistry, or there's something called Handy Dot, where I think they may assist with that as well. I hope that was helpful to understand. If you've got questions, do reach out. Okay. Irmel Yasalad asks, are you in Ottawa? We have an office in Ottawa, so if you want to reach out to our firm, you can go to disabilityrights.ca, which you likely will see on the screen soon, and reach out to our intake team, and they can connect you to our office in Ottawa. Lapis Lazuli, let me just scroll down, asked, does having a spouse change your insurance coverage amounts? My insurer has been very interested in whether or not I live with my partner and asking questions about it. Why? I'm not sure what coverage we're speaking about, but if it is, am I receiving long-term disability benefits? And now the insurance company is asking me whether I live with my spouse. When they ask these questions, I'll backtrack for a moment. Sometimes insurance companies may conduct what is called a functional telephone interview the moment that you've submitted your claim. So they're trying to establish information, get information from you regarding your activities of daily living. They may ask you questions like, where do you live? Is it a house? Is it a condo? Is it a townhouse? Do you live by yourself? If you're not living by yourself, who lives with you? Is it your spouse? Because you're trying to establish who lives with you, who does the household chores, who cooks, who cleans, do you do your banking, do you have any assistance, do you have children, who drives the children to school, how do they get to school, who prepares their meals, etc. They're trying to establish function. What is it that you're doing outside of work to see whether they're going to be approving your claim? It's a very generalized statement, but they're trying to establish what is happening in your life outside of work. Is there another reason why you are not working or choosing not to work? So be careful when you respond to those questions. You have to consider, why is it that I cannot work? Of course, there's a difference between being able to feed your children and performing a job. But function is always paramount in assessing a disability claim, and that's why those questions are being asked. I hope that was what you wanted to know, if that's what we were speaking about. If not, you can ask another question to maybe clarify. Okay, another question on YouTube, this time from Ron. I've struggled with CPTSD, complex PTSD, for the last several years, and I've been seeing a psychologist for this. Recently, my symptoms have worsened and I'm off work. My insurer is arguing that this is a pre-existing condition. Is this true? Is there anything I can do? Ron, I'm sorry that you're struggling with this. The fact that they are telling you that it is a pre-existing condition tells me that you very recently, or at least within the first year of having coverage, went off work. What that means is the vast majority of LTD policies provide that if you go off work within the first year, some have 2 years in that timeline, but most of them will have 1 year. If you go off work within the first year of having coverage, the insurance company will assess whether your disability is directly or indirectly related to a pre-existing condition. Pre-existing condition will also be a defined term, and it may be something for which you received treatment or medical care, or you were taking prescription medication during a specified period of time. I'll use an example. If you start working on January 1 of 2025, and you go off work today, which is May the 13th of 2025, that's within the first year of having coverage. Now, the insurance company is going to investigate whether your condition is pre-existing or your disability is related to a pre-existing condition. The policy may define pre-existing condition as a condition for which you receive treatment during the 90 days before your coverage commenced. In other words, from October the 1st until December the 31st, did you receive medical care for a condition which is directly or indirectly related to your current disability? That's just an example. All the insurance companies have different pre-existing condition exclusions or language, and that timeline may be 90 days before coverage started, or 90 days before and after coverage started, or is there a moving 13-week period in which you did not receive treatment? It really depends on the language of your policy. So in your situation, Ron, when you ask, is there anything that you can do and are they correct? The only way to answer that question is to review the claim. In other words, to review the denial letter, to discuss with you what your medical condition is that has resulted in you being unable to work, why they're saying this is a pre-existing condition, and then reviewing the medical documents to see whether indeed it is. We have had lots of people contact us, and it will always continue to happen. On a weekly basis, my colleagues and I get consulted by people who have had their claims denied due to pre-existing conditions. And in some cases, an argument can be made that it is not pre-existing. Often we can. But in some cases, clearly it is pre-existing and nothing can be done. But the only way to know is for us to assess it. Okay. Question from Serena3003. I'm transitioning from STD, short-term disability benefits, to long-term disability benefits, and I'm a bit confused by the application process. My insurer is saying I don't have enough documentation, but I was approved for the short-term disability coverage. What else do they need? Well, they need to tell you what they need. Often, let's do it this way. Short-term may not be assessed by the same entity, or it may be. Often short-term is paid by the employer, but assessed by an insurance company. And then long-term is assessed by usually the same insurance company or sometimes a different insurance company. But it will be assessed by a different department if it is the same insurance company. They may say to you, yes, we approve short-term, but now we're looking into this in more depth, which I often agree with you. It's a strange position to take that on. Yesterday we accepted your claim, but today we're going to want more information because you're now transitioning. What else do they need? They may be requiring your doctor to provide medical documents, in other words, your clinical records, or they may be requiring your doctor to complete a form to address what your condition is, what your restrictions and limitations are, whether you're able to work in a graduated return to work program, and what the prognosis may be. So it depends on what they are wanting. And if they haven't told you, ask them, what else do you require? So you can be proactive with this. If they deny you, please reach out to us so we can have a discussion with you as to what your options are. I want to go back to Ron's question on the complex PTSD, just to understand. If you have been seen by a physician or a psychologist or a psychiatrist, let's say you have PTSD, complex PTSD in this case, but you also have anxiety, and you were being seen for anxiety, you were on medications that kept your condition stable, then you started working, you go off work within the first year of having the coverage. But this is due to complex PTSD, which you did have before, but it's now worse, and you were not being treated for it. Then it's not pre-existing. It really depends on your situation and your specific circumstances. I've pursued claims, and so have my colleagues, where there was a pre-existing condition argument because the person was receiving treatment for their mental health, But the disabling condition ultimately was a different mental health condition. So the argument can be made that it is not pre-existing. Do not simply accept that when an insurance company tells you we are denying your claim because it is a pre-existing condition, that they are correct. Sometimes they are, I agree, but often they are not. And that's why you want to have a lawyer who deals with long-term disability cases, who is familiar with insurance policies, review your claim. Serena says, I see they're not the easiest to deal with, so I appreciate the insight. I will ask them for a detailed list of their needs. Do have them tell you what they need. What is it that they're looking at? They cannot simply say to you, we need more information. What is it? They have a duty to deal with you in a fair manner and an objective manner. They owe you a duty of care. So you can be the squeaky wheel and say, look, my claim was approved until this day. Now you want new information. What is it that you want? Maybe I can assist getting that information for you. And try and document everything when you speak to them. Okay, question from Michelle. Another one on YouTube. I've been on disability claim for about 4 years because of some physical and mental health issues. I was placed under surveillance and my benefits were cut off. Why would this have happened? Insurance companies can conduct surveillance at any time and you won't know. Sometimes you will know if they send you a activity log to complete. They say, send you a bunch of documents with activity logs to be completed for every day for maybe 2 weeks. If they do that, they're asking you to document what you do every hour, by the hour, for 2 weeks. That may be a sign that they're going to be conducting surveillance, because what they will do is they will review the forms, the activity logs that you complete, and compare it to what they see on surveillance. And if there is an inconsistency, in other words, you may not have told them that you were taking the kids to school, that you were going to drive around to Tim Hortons, go to the store, come back, or that you were taking out the garbage, or visiting friends, or doing work in the garden, or you may have said, I slept, or you were vague in the completion of those activity logs. They may look at that and say, well, your reports of your activity and your function would be inconsistent with what we observed on surveillance. Therefore, we are going to deny your claim because we do not accept that you are continuing to be totally disabled. So why would they do that, Michelle? I cannot say why they did that in your particular circumstance, but it may be that they're looking at it and say, well, your condition isn't improving. You've been seeing these various doctors. You're receiving this treatment. We're going to investigate ourselves what your activity looks like. It's unfortunate, and I know it's something that's unpleasant, but again, if they deny you, like they've done here, do not simply accept that they are correct. Contact us and we can review your situation with you. Okay, then there's one more question. I'll see if we can get through this one. YouTube is popular today, so one from Mina, also on YouTube. Can a disability lawyer help with an LTD claim for a unionized worker? Yes, for the most part, but not in all cases. Some situations you will have a collective bargaining agreement that provides that you cannot pursue your denial through a civil court. In other words, you cannot pursue a legal claim. You have to go through with a mandatory appeal process where you will have the union assist you, and where if you end up in front of something called a claims review committee, for example, where benefits are paid by a trust and the insurance company adjudicates the claim, they don't actually pay the claim. The collective bargaining agreement may provide that the decision is final and binding. Still consult a lawyer, but I'm not sure if the lawyer will be able to assist you. So I suppose the main response to this would be, yes, often we do help unionized employees. Having said that, we cannot do it in all cases. And the only way to know is if you were to contact us and we can review with you the collective bargaining agreement to see whether it is a claim that we are able to assist in. I know I and all my colleagues continue to have unionized employee cases in our caseloads. So for the most part, we should be able to assist, but in some we cannot. So that was quick. Thank you for tuning in. The next session, well, next live stream is an employment law Q&A on Wednesday, which is tomorrow, May the 14th, at 1 p.m. Eastern Standard Time with Samfiru. which will be 10, am I going to get this right again? 10 o'clock, 10 a.m. Pacific Standard Time, and 11 in Alberta a.m. Thank you for tuning in, and hope to see everyone soon.